SJC-13323, Commonwealth v. Shamia Whitfield.
Okay, Attorney Sherman, whenever you're ready.
Good morning, and may it please the court, Catherine Sherman on behalf of the Commonwealth, asking this court to vacate the judge's discovery order and remand this case for further proceedings in front of any judges of the Boston Municipal Court.
How is this a disclosure of the informant's identity?
The volume of disclosure of information being disclosed here is tantamount to disclosure.
It's promises, rewards, and inducements, correct?
That was the title of the defendant's motion. However, in the body of it, and I can get the exact language, it's basically asking for the CI's entire history with the Boston Police Department and any other agency every time they've interacted, every time they've had contact, every time the BPD has received a tip. It basically creates a web of information that would be tantamount to disclosing the CI's identity.
All our cases are identity cases, correct? There are no tantamount to identity cases.
Well, Imral uses the language tantamount, and additionally,
Because as I look at it, then you'd be under Rule 14, material and relevant standards, as opposed to informant privilege, correct?
no, I believe it would still fall under the privilege. So
If we don't find it to be identity, then it's a Rule 14, material and relevant standard, correct?
yes, if you consider the volume of information not to be tantamount to revealing the identity. And if I may, looking at what was ordered and what was requested in the defendant's motion, I would argue that this is a situation where the whole reveals more than the sum of the parts. If this is a person who's been in this defendant's home, as we believe they are because the affidavit is considered to be truthful and reliable, the volume of information that would be given to the defendant would be an amount of information from which they may be able to
So we have
discern
vague
the
references,
identity.
of course, to personal knowledge, when and where, or when, rather. Are you saying that the records would say something like they were there on June 13th? They were there on, and the defendant could say, I know who was there on June 13th and June 14th.
If I may, I'll grab the exact language of what was ordered, because the judge did allow the motion in full. So though it would not force the Commonwealth to reveal the days upon which they were in the defendant's home in this case, it would reveal other information that I believe the identity could be discerned from that, such as the names of all of the other cases they were involved in, and a history which would include a timeline of their involvement with the Boston Police Department. And though the references to time for this particular defendant are vague, it is, I believe, 3 occasions within the last 30 days. So that is already a rather tight timeline. And it's 3 occasions in the last 30 days during which the CI saw the firearm, saw live rounds being ejected from them.
We'd agree
so it
that,
is narrowed.
that our analysis goes on 2 very disparate paths if it's an informant privilege case or a Rule 14 case, correct?
It would.
One, you have the burden, the other one, you don't.
That would be true. Though I would.
I mean, because obviously the judge has great discretion to determine what is material and relevant in a Rule 14 as opposed to reliance on the informant privilege, correct?
That is true, though when it comes to revealing this amount of information, it's not a circumstance where they're being asked.
I don't want to sidetrack, I've got all the information I need, but
Sure.
I don't want to sidetrack your argument
Okay.
on these
I
two
just,
paths.
I would argue that since tantamount is recognized in Amaral, and I know it's an appeals court case, but in John, if this is not tantamount, I can't imagine what is. It's asking for discovery far beyond Rule 14, far beyond Rule 17. It's asking for discovery from federal agencies. It's asking for a complete history of this person's interaction with law enforcement, and if that isn't a direct threat to their safety, I can't imagine what is. The record in this case,
Well, their name.
their name, yes, that would be the most direct.
Yes.
It would be.
So one can imagine.
But in the world where we're talking about tantamount to revealing the identity, short of a name, I think this is, it's presenting essentially the mosaic theory of identity. It's asking for all that they have been doing with law enforcement and how to connect those dots to narrow it down to one person.
So could that be cured, I guess, by a protective order in any way?
No. So
Why not?
a protective order is the absolute last step of discovery. The last step being discovery is properly ordered, all privileges are vetted, and the protective order then narrows what is given to defendant or defense. In this case, where there isn't any articulated purpose to this discovery, to a pretrial defense, to a trial defense, there is no basis on which to judge what ought to be the subject of the protective order or not. And the defendant's brief makes much of the fact that defense counsel below was urging a protective order, that discovery ought to be provided subject to protective order. But Mass Rule of Criminal Procedure 14 itself says that the existence of a protective order or the protective order as a mechanism in no way reduces the burden of proof with regard to the discovery, including those that are subject to privileges. If a protective order can be the first step in assessing whether or not discovery ought to be granted, then every privilege would be eviscerated, not just CI, but you'd imagine psychotherapists, we wouldn't be going through Lampron Dwyer, there wouldn't be any protocols for that anymore. It would just be, well, we'll disclose all of these psychological records subject to a protective order, and that would be, it would get rid of the privileges if that were the lens through which a protective order were considered the solution in these situations. Here, in the long history of this case, in terms of the motions to reconsider the judge's evaluation of the case, never in the transcripts, in the filings, did the defendant articulate a pretrial motion to which this discovery would be relevant or a trial defense. There were no facts presented in defense counsel's affidavit. All that was suggested is that the information is necessary to prepare for trial. And the motion judge in this case took that conclusory statement and extrapolated from it a confusing legal standard for which she found the discovery ought to be provided. That said, none of what she was basing her decision on is rooted in the law of this court or any other courts of the Commonwealth. There was no basis. This order must be vacated. If it's not, it's essentially doing away with the CI privilege. If the court has no further questions, I will rest on my brief.
Okay, thank you.
Thank you.
Attorney Locke. I'm sorry, Attorney Warren, apologize.
Good morning, Chief Justice, and may it please the court. John Warren on behalf of Shamia Whitfield. We are asking that this court affirm the motion judge's allowance of the discovery order in this case. First, I would suggest that this is not a disclosure case. Ms. Whitfield never requested the identity of the informant, the judge never ordered it, and the judge made a finding that her order would not otherwise reveal it.
I think, well, we have these two paths, and we're going to decide, and I think, I'm more interested, say we think it is, because I think if it isn't an order, and you get to Rule 14, you've got a good argument, because of the discretion to the judge. Say we think it is tantamount, right? I think it's a harder case for you. How do you get to where you want to be, where defendant writes, I need this to prepare for trial?
So,
How does that satisfy any type of?
well, I would direct the court to the discovery motion itself, because the Commonwealth claims here that there's no asserted pretrial motion. That's just not true on this record. The discovery motion itself says, I need this to relevant for an AMRAL challenge to the veracity and completeness of the warrant affidavit. Turning the court's attention
But
to...
wouldn't that be the case in every search warrant? If all we require is the defendant to say, because they have track record, and you've seen 1,000 of these, right? And it all says the same thing, information led to seizure of drugs or guns. And then defendant says, well, I need this for an AMRAL hearing. I think the informant's lying or made up or whatever, then the privilege is gone, right?
What I would suggest is that trial court judges should have wide discretion to order non-identifying discovery regarding an informant's track record.
All right, we're getting to that divide. I want you to assume, for the sake of this argument, or this question rather, that it's identifying, okay? Now what?
Well, I think to get to that hurdle, the judge's finding would have to be erroneous, right? I mean,
So we have something that's going to be tantamount, and it's a search warrant with the track record that we just discussed. And the defendant says, I don't like this, I want to file an AMRAL Frank's hearing. What's the standard?
So the standard should be that judges have broad discretion where the affiant is relying on the asserted reliability of an informant, but the warrant does not include detail or specificity as to that reliability. Where it's just this person's reliable, but there's no detail or specificity. A judge in those circumstances should have wide discretion to order non-identifying discovery.
The affiant has to say, they bought drugs on such and such occasion at such and such. Really, you want them to be that specific?
Right. I mean, right. I think if they're not that specific and they're saying this person's reliable, then a defendant gets discovery as to some details or specifics. And so that would be the general rule.
Why doesn't the defendant get to challenge step one of Aguilar and Spinelli? I mean, isn't that the issue? The issue is whether or not there's veracity in the four corners of the affidavit, not whether or not there's so much discovery requested under Rule 14 and Rule 17 that the informant is known to the world.
Ms. Whitfield might have a separate motion to suppress challenge under Aguilar Spinelli. That might be the case. She might have a strong challenge. However, looking at that line of cases, courts give a good amount of deference to affidavits that assert the reliability of an informant. And so what I would suggest is it's just not good enough to say you can go challenge the four corners.
A lot of cases. We got to take out big erasers to do that. The issue is whether or not there's enough to satisfy veracity. If there isn't, then the motion to suppress should be allowed, absent the corroboration that makes up for it. But if the issue is, oh, I don't like veracity here, here's my motion, let's go to my Frank's hearing, that's every case where you don't think veracity is satisfied.
So we're not saying let's go to a Frank's hearing, because that's sort of the ultimate stage, the suppression
Let's go to AMRAL to see if we go to Frank's.
And we're not even saying let's go to AMRAL. We're saying just give us some discovery. The defense counsel in this case did not pursue the case in the way that the Gandia case was pursued, which is we need the identity. And, you know, that works out pretty well for defendants.
Well, that's what we're getting to the tantamount issue, which I think is.
Well, that's the key. That's the key,
I agree
right?
with that, yeah.
If Your Honor says.
Then you don't have to deal with then you don't have to deal with the informant privilege, and you probably win.
Right, but what I'm saying, right, exactly, Your Honor, and what I was saying is defense could have gone about it and said, we need the identity, and as we see in cases, the Commonwealth says we're not going to give it up, and cases get dismissed that way. Ms. Whitfield did not proceed in this case. What she said is, we want to be able to test the veracity because you're saying this person is so reliable, you give the vague contours of an impressive track record, but there's no detail, no specificity.
It's different
to
in
back
this
it up.
case than every other case, though, when we
Well-
have a sketchy track record.
I mean, again, I think the general rule should be judges should get broad discretion where it's a vague, but
Well,
vague sort
Counsel,
of.
if I could go backwards, one, it's nice to see you again, Attorney Warren.
Good to see you. Your Honor.
Those cases get dumped at the motion to suppress, right? Because that's where the Commonwealth is forced with the Hobson's choice of either and every once in a while they'll proceed under Bacoyan, but most often they'll dump it. Okay, so they don't dump it at pretrial. But I want to go back to this idea that there is something in just saying the name. You wanted, or Attorney Kenny asked for, debriefing reports, Form 8s, 2494 requests for funds, history of involvement with police or any law enforcement agency, list of results of all cases that the informant has worked on. This isn't something where we're just saying, we just don't want the name. This is everything but the name. And and we know how this works. This gets turned over, and you can look in and see what's been turned over and localize who was there when to get some idea of who we're talking about.
That's definitely, I would suggest, not the purpose of getting the information. And you know, I don't necessarily think it's a voluminous amount of information. It might be several reports. We don't know exactly, you know, the Commonwealth is in the position to know exactly what the information is. We do have the Boston Police Department rule. We know what they should be collecting and maintaining under that rule. So we can get a sense of what it would look like. But what I would suggest in this case is the Commonwealth, they didn't make a sufficient showing as to why this discovery would lead to the disclosure of this informant. All they did here was make generalized suggestions that would apply to any informant.
Okay.
And so there was no specific showing.
So if you could indulge me, like Justice Gaziano, assume for the sake of argument that there's tantamount language and this is tantamount, and then we go on to look at the second part. I saw you sitting here the case before. The defendant was able to articulate why, I mean, may not carry the day, but why the identity of the CI would have been important to the defense. Here, there's no math. What's the math as to how under the Bonnet test are we supposed to determine whether or not this is important to the defense, where all you're given is it's important to the defense?
It wouldn't, Your Honor. It wouldn't. What I'm saying is this case rises and falls under whether the discovery is material and relevant to an AMRAL challenge. We don't want the identity, and frankly, we don't want information that's going to reveal the identity. And that's what Ms. Whitfield stated in her initial motion.
But it's always going to be material and relevant to an AMRAL, the track record, that information.
And I think judges should be given that discretion to order it, and you know, with protective orders.
It'll be ordered in every case.
What I would suggest,
It will be ordered in every case.
why I think this case is I would suggest as a general rule, as I might have said, where there's a claim of reliability but no detail or specificity to back it up, then that's a situation where judges should get this discretion. Why is it really important in this case? Because in this case, this is not like many other warrants we see, because in this case, it's based on a tip from a sole informant that was uncorroborated by police in any material way. And what that does to the materiality in this case is it puts a lot of pressure, it puts a lot of weight on the informant's reliability. It's asking the reliability to do a lot, because this is not like a controlled by case where police are there supervising and corroborating the informant's tip. It's not like one of the cases where there's an armed robbery and police have probable cause for the armed robbery. Now they want the clothes and the gun in the home. The only allegation specifically with respect to Miss Whitfield was from this informant. And the only corroboration was that she lived there. There was no other corroboration about this tip. And so that's why the reliability in this case is so important, because
That doesn't answer if you're in the informant category. because
We lose.
Right, because a mere tipster, there's not disclosure.
right, I mean, there needs to be a way to fashion discovery orders that don't lead to the informant's identity. And from the very beginning of this case, that's what attorney in 2019 tried to do, is say, I don't want the identity. I don't want materials that are going to lead to identity. I'll sign a protective order. I want materials so that I can make a challenge or potential challenge to the veracity and completeness of the warrant affidavit. And so, again, what makes this case strong is that there's an assertion for reliability. There's not the detail or specificity to back it up. That the defense cited to the Boston Police Department rules, which lay out exactly what the BPD generates and maintains with respect to confidential informants, and the judge considered that and ordered those materials, which we know should exist. And I think the alternative is that if this court says, no, you don't get any of this, you don't get any of this, that police departments are incentivized to craft affidavits in just this way, where they say, this person is extremely reliable, they have an impressive track record, but you get none of the details about that and none of the specifics. And what I would suggest that does is insulates affidavits from any Amaral Franks challenge. And that's really a problem, I would suggest.
Although here we have, on at least 3 separate occasions, officers were directed by the informant to a specific location in Dorchester or Roxbury. On each of those occasions, the informant directed officers to investigate individuals who were unlawful possession of a firearm each time they found was in possession. I mean, there's some detail here. It's not, I'm not saying it's astronomical amount, but it's not just, there's some specifics here, right?
There's some information that what I would say that suggests this person's been used in the past. They have a track record of sorts, but no detail that would actually allow for a defense to make a challenge to it.
So walk me through that. What would be enough?
Like
on October 10th, 2007?
Right.
I mean, is that what you're missing?
I think if the affidavit has docket numbers and has defendants' names and has dates, the warrant, we would be in a different position.
But it's a fine line, because the more specific it is, the more likely it is to reveal the identity, right? So,
Yeah, there's a sweet spot between discovery and revealing the information, correct?
Correct. There is a sweet spot. And I think that's what Attorney Kenny, from the outset, was looking for. And that's why he repeatedly said protective order.
I'm not going to read it out loud, but if you read A and what's requested, I won't read all of it, but not limited to cases where the tip by the informant turned out to be raised as accurate or inaccurate, including federal agencies. Of course, the federal agencies aren't going to turn it over. So you got that.
And if one part of the order is not discoverable, I don't think that would invalidate the whole order. But What I think, I would just want to make this point about why the motion judge did not err, because I think Your Honors are right that the key is the finding, the motion judge's finding that this would not disclose the informant's identity. We're not saying this case should go to Roviaro and Bonet. We're not saying it should go there. So it does rise and fall on that sort of analysis. And the three reasons why the motion judge was, motion judge's finding was proper is because the Commonwealth did not make a showing that this information would reveal this informant's identity. And they did not say why a protective order or other prophylactic remedy would not suffice. Because there's nothing on the face of this order that would reveal the informant's identity, where the judge ordered the Commonwealth to disclose it using a code number. And because this is a case where the Commonwealth has already disclosed that the informant was in Ms. Whitfield's home within a 30-day time period, and all the defense was looking here was the prior track record, not dealings with Ms. Whitfield, but the prior track record that the Boston Police affiant says was reliable. And Ms. Whitfield is entitled to information, and the judge has discretion to order information that relates to that reliability.